So today we'll be covering how to structure your business in terms of the corporate structure. Then we'll look at how to organize your operations. Then we'll move on to the really juicy stuff around preparing for future opportunities and liabilities. And then we'll end the formal presentation by looking at intellectual property. There is some time at the end for questions, but also we're happy to take questions as we go throughout the presentation. And I'll keep an eye on the instant messaging questions if you prefer, not to ask them, but to send us a message. So with that, I'll hand over to Jennifer.
Perfect. So I think to kick off, we just wanted to provide a little bit of context as to the stages that a business may go through in terms of its life cycle. And typically that would be moving from startup through to sort of growth, consolidation, and then finally into sort of maturity and exit. And really the intention today is to walk you through those 4 key legal considerations that every business owner needs to know within that context. Each legal consideration will often have a bigger priority at certain stages of this life cycle, and it will depend on your business needs and structure. So for example, is IP critical to your business? It may be more important at the earlier stage than later. Same with sort of when you're employing employees, requesting funding, etc. So really that was sort of the structure we wanted to use today for our presentation. So moving on to the next slide. The first topic we wanted to cover was corporate structures. And appreciate this, a number of you may have already been incorporated. But the 5, here we were just setting out I suppose the 5 key legal structures that you would typically see for companies. It doesn't cover all the legal structures. For example, this doesn't include a charitable incorporated association. But the 5 key ones are set out here. So you've got sole trader, one person carrying on their own business, sort of the private company structure, whether shares or limited by guarantee. And then you've got the end of the slide here, sort of partnership style structures. So if we move on to the next slide, the things to flag around sort of structuring of businesses in general. And again, these sort of business considerations will and can change throughout your business life cycle. It may be that you start as a sole trader, and actually as your business expands and you're considering bringing in other sort of business partners, that you may want to change your structure. So when you are thinking about business structure generally, the key things you want to focus on are ownership structure is the first point, which really means, do you want a separate legal entity? A lot of the time the answer is yes, given that protects you from liabilities arising in your business, so you're not personally liable. And that business can enter into contracts, hire employees, for example. You will also want to think about the number of owners that you currently have and actually in future may have. So again, if you're anticipating having a broad ownership base, having a private company limited by shares, for example, can be very helpful, because you can tailor share classes and share rights to really reflect what ownership rights everyone should have. The second point is, do you need an ability to distribute profits? And again, that goes to whether you perhaps a charitable or a for-profit organization. So again, some of you on this call may be charitable incorporated associations or private limited companies by guarantee, which are more typically used for charitable structures, whereas companies limited by shares and partnerships are often used for profit organizations. The third point to bear in mind is around privacy and administration. There will be filing requirements and some level of public disclosure for limited liability partnerships and companies limited by shares. You have to register at Companies House and file certain forms publicly. The fourth point to bear in mind is, what do you envisage will be your client and supplier base? Who will you be engaging with? Where will they be based, and what will they expect in terms of the entity that they're contracting with? Sometimes, companies, counterparties will require that they are that separate legal entity, so that you've got that formal structure in place and formal contracts that govern who's responsible for what. The fifth point here was around future financing and availability and location of that financing, and we'll come on a little later to talk about some of the key considerations with third-party financing in general. But from an early stage, if you're looking to seek third-party financing, it's worth considering whether your structure is appropriate to receive that, or whether you might need to restructure to make sure that you have the right corporate structure to protect your interests, as well as entice investors to join you as well. So, for example, if your investor base is in the US, often you can see requests from US investors for certain types of structures, and maybe even a US topco company, which again is where us lawyers get involved and help you out in terms of making your structure as great as possible. And then the next point was location of employees. Where are they based? Will you have employees? So for example, some structures you can't hire employees, so partnerships and sole traders. And then there are also tax considerations around where employees are based, who their employing entity is. So that's always worth bearing in mind, as you start to employ employees. And I think my tax colleagues will come on to some of the the tax implications of employment relationships. And finally, you have IP, and that will be a topic that we'll come to talk about a little later on in the presentation. So they're the handful of points from a more broad, general perspective. And I'll hand over to Trevor and Harry on the tax side.
Thanks, Jennifer. We'll just touch on a few tax considerations for early stage businesses, but ultimately, as Jennifer noted, the choice of structure will be based upon the individual needs and the requirements of the business and the situation. Now, many early stage businesses will start out as sole traders, which is essentially the most straightforward from a tax administration perspective. So the sole trader will register with HMRC and submit self-assessment tax returns each year, and pay income tax at 20 to 45% on all taxable earnings, as well as national insurance contributions. Now, these rates will apply regardless of whether or not they extract these profits for personal use or invest them back into the business. Now, as the business develops, a limited company tends to offer a more tax efficient structure for the growing company. Owners can pay themselves a small salary and extract further profits as dividends, the benefit being that these are taxed at a lower rate, and national insurance contributions are not payable on the dividends themselves. Now, the owner may also decide to leave surplus profits in the business to either reinvest or withdraw at a later time. Now, limited companies themselves will pay corporation tax. Now, this is at a rate of between 19 and 25%, depending on the company's profits. The effect of this is ultimately that it allows a higher percentage of the company's profits to be reinvested, so 75% or even up to 81% for companies with profits below £50,000. Now, compare this to the sole trader position that are subject to income tax. They may only be able to reinvest 60 or even 55% for those higher rate income tax payers. Now, as well as the ability to reinvest a higher percentage of profits back into the company, limited companies qualify for a wider range of allowances and tax deductible expenses. So you may be familiar with businesses claiming tax relief for business-related expenses or some or all of the value of an item that the business purchases. So this could include equipment and machinery or patents and know-how. But for limited companies, there are further reliefs available. For example, if the company is involved in the development of intellectual property, which results in certain patent registrations, the patent box regime allows these companies to apply a lower rate of corporation tax at 10% to the profits earned from those patented inventions. A further example could be expenditure on research and development. This may apply to businesses that are taking a risk by innovating or improving on a particular process, product, or service. Now, this is obviously subject to a number of criteria, but for those companies that do qualify for this enhanced reduction, they may be able to claim 186% of the R&D expenditure. Now, moving on to other benefits to early stage companies, there are certain investment schemes that are available, and these essentially work by offering tax relief to the individuals that make the investment in these early stage companies. The companies obviously have to qualify under these schemes, but these schemes were ultimately introduced to encourage these individuals to invest in these smaller companies and to help alleviate the problems that you'll probably face as an early stage company to raise finances. Now, just touching on VAT briefly, like sole traders, limited companies can voluntarily register for VAT as well. And this does also become mandatory again once the taxable turnover reaches £85,000. I now hand back over to Jennifer to continue the presentation.
Thanks, Harry. So next we're going to move on to the second key consideration, how to structure operations legally. And the first part we wanted to touch upon was sort of your contractual incorporation documents. So setting them up, to essentially protect the goals of your business and what you're trying to achieve is, very important from an early perspective, particularly as I say, if you bring in other, whether it's partners, whether it's third-party investors, whether employees are going to get shares, just really to protect the value of the business and the control that you have over that business. And often founders for profit, who are running for profit organizations will be focused on those two concepts of, retaining value and retaining control. And we've set the slides up in that lens, looking at predominantly sort of how you do that for a private company limited by shares, although a number of these rights will be applicable to other structures in some guise, although the terminology may be slightly different. So, to start with, what are your incorporation documents? What would you be looking to put rights and restrictions into? For a private company limited by shares, that would be your set of articles that you file publicly at Companies House that are required by the Companies Act and that have to follow a certain form, although they can be tailored, to your business needs. And then you've also got a shareholders agreement that often sits alongside the articles, so they work together. But the shareholders agreement is a private contract that works between the owners of the business to make sure that it's run in accordance with their wishes. And, we wanted really to touch on the key categories of things that you should be thinking about from an early stage. And some of these may only become relevant as you move through your life cycle. But I think it's always worth considering them right from the outset so you have the right contractual agreements in place. So the first bucket of things to consider will be share rights. So what class of share will people hold? Will they have ordinary shares? Will they have preferred shares, which essentially means shares that are given a priority above the ordinary? For example, they're paid out first on exit. You're looking at economic rights. If the business makes money, or if it doesn't make money and it liquidates, what should happen? Who should be paid out first? So dividends, obviously, that's distributions of cash in good times. A liquidation preference can happen at numerous points of a life cycle. Hopefully, it would be exit. And should you or a certain class of shareholder have priority when the business is sold and the money is distributed? You then need to consider voting rights. So should all shares vote equally, or should there be arrangements in place that allow you or, again, a class of shareholder to have certain preferred rights, including a set of reserved matters? So, for example, certain things that are critical to the business, big acquisitions and disposals, issuances of shares, things that would change the, change the business. Should someone have a say over those, essentially a veto right? You then move on to board rights. And that's really the governance of your company. The board are responsible for the day-to-day operations. So who should be able to appoint those directors? Who should be able to remove those directors? And how should those board meetings be run? Should resolutions be passed via a majority? Should there be one director that always has a say in matters? And then more administratively, how often should you have meetings? Who should chair meetings? And what should happen if there are conflicts of interest more broadly, in terms of whether they sit with a board hat and an employee hat, or they sit in a competitor business, just to protect the board operations. So moving on to the next slide. The third category to consider is around issuance, transfer, and sale rights. So issuance rights, that there are sort of two categories here, but essentially this is protection that if the business needs more money going forward and you issue more shares or ownership rights, do they have to be offered to the existing shareholders first, or a particular shareholder, before they're offered to third parties? So that's all often one that shareholders are keen to negotiate and have the right to participate. They can turn it down if they want to, but it allows them to keep their pro rata share in the company. And then anti-dilution's an even more protective provision. You'd often see this if a third-party investor came in, a little later in your company's journey. And this essentially would protect an investor that if you issued shares to them of a certain price, and then later, and then a week later you issue shares at a much lower price, they are then protected for that down round, for that lower price that's been offered, and they would be issued more shares to essentially make them whole, and be treated as if they had their shares offered at that same price. You then have transfer restrictions, and that's really to protect you against people leaving the business. So should certain transfers be permitted? Can people transfer to their family members? And if so, are there any conditions attached to that? If they want to transfer shares, should they be offered to existing shareholders before they can transfer to third parties? So again, making sure that you have control over whomever you are left operating the business with. The third point, and probably one of the most critical at early stage companies, particularly if you put in place employee share option plans and grant, or potentially you're granting rights to consultants or advisors, is the drag along provision, which essentially allows the majority, or perhaps the founder or lead investor, that if they want to sell all their shares, so you want to exit your business, you can drag everybody else into that sale and essentially deliver a clean sale to an incoming investor. And then compulsory transfers, who should, if someone's done something, for example, they're a bad leaver, they've committed fraud or gross misconduct, hopefully they haven't, but if they have, then, do you want to be able to claim back those shares or buy them back at a certain price to ensure you're not left, in business with those people? And then exit is probably the final point around, making sure that you are considering, what is your plan for the future? What do you want to happen? When would you want to seek an exit? And then, always there are a few other considerations we just wanted to note here. So I touched upon sort of good, bad levers. Restrictive covenants will come to a little later on in the employment context. And then information rights, that might just be something that investors request as you go down the line. So I'll now hand over. I think the next slide we've got here is a little bit more around directorship. So Sam, I think this one's you.
Thanks, Jennifer. Hi everyone. So this slide just looks a bit further at directors. So to start off, I think it's important to say that obviously in the early stages of a startup company, the founders are the sole shareholders, and they're likely to be the directors as well. So the need for having a board of directors is less of a priority. But really the key point here is that as the company grows, it's important to think about appropriate governance and trying to, trying to appoint individuals to the board that are going to have the skills that are set out in the top row on the slide here. So thinking about potentially appointing non-executive directors or board advisors, because this is going to be seen as very valuable to incoming investors, that having a board with a range of advisors with a range of skills that can help the company. So really having individuals with the appropriate expertise, with management experience, people that are going to be able to spend time building the company and helping you as a founder, and also individuals that have the relationships in the specific industries is going to be helpful. So looking at the sort of types of individuals that might be on the board, you have the executive directors, which, as I said, is at the start largely the founders. These are the people that have the power to influence the strategy and the decision making of the business. They are, however, constrained to abide by the by duties under the Companies Act, which are statutory obligations. Then, as I said, you may want to bring in non-executive directors as the company grows. So these are not employees of the company, and often are meant to be impartial and have no interest or involvement in the company. And the idea is that their impartiality will bring good corporate governance, but that often has to be weighed against wanting an advisor who is appropriately sort of incentivized and remunerated in shares or share options, as we'll go on to talk about. But these are the individuals that will really have the wealth of experience, the contacts and the connections in the specific industries, and that they'll be well-respected business leaders. And then another type of individual that may come on in the future is the investor director. So these are people that might request to be added as a director of the board as part of their bringing investment and cash into the business. And in this case, it's important to think about your sort of makeup of the board. If it's just yourself as a founder and then an investor director, you might want to think about having a non-executive director as well, and thinking about an odd number of directors to avoid a deadlock in decision making. And then finally, the chair, as I think Jennifer mentioned, they're really the sort of head of the board. They will take the chair at the general meetings and board meetings, manage the structure, and then ensure communication with the shareholders of the company. So looking then at the lower row in this slide, this just sets out very quickly the statutory duties that directors of the company have to abide by. And this is because the directors have what's known as a fiduciary position in relation to the company, because of their sort of position of trust and confidence. And these duties, if they are breached, the directors can be personally liable to compensate the company for any loss which it suffers due to that breach. So just to very quickly touch on a couple. The first one there, the directors must act within their powers. As Jennifer mentioned, the articles are sort of the governing document of the company. So that's where the powers of the directors will be set out, and they've got to abide by that. The director's got to promote the success of the company, and that duty is often sort of judged by reference to a number of factors. For example, the directors should think about the impact of their decisions in the long term, the impact of their decisions on the company's employees and their suppliers and their customers. And then just to pick a final few, the directors have got to exercise reasonable care, skill and judgment, which is an objective test. And then finally, avoid conflicts of interest. So as Jennifer mentioned, whether it's the director sitting on the board of a competing company or whether it's a sort of personal gain risk situation, these are things that need to be thought about at all times. And then if we go to the next slide, just to move on to the next section, this is really just a sort of reminder of things that need to be thought about right from incorporation. The company has a duty to keep records, as you can see on the slide, of all sorts of things. So registers of directors, shareholders, accounting records, resolutions. So that's the sort of records of the decisions taken at the meetings. And then, as Harry mentioned, also tax returns and tax records. These are all things that need to be kept. So that's just to sort of remind that these things need to be thought about. And then onto the next slide, I think we're back to Jennifer, who's going to talk about the opportunities and liabilities.
Great, thanks, Sam. So we're now moving on to the third legal consideration to keep in mind, and that's really how to navigate potential future opportunities and liabilities, and the key considerations and pitfalls in these four key things that you'll come across in your sort of life cycle. Some of these probably earlier than others. So the first thing we wanted to touch upon was sort of employment and advisor contracts and what you should be looking for and thinking about when you are putting those arrangements in place. And the first point was the relationship classification. So really thinking about what that person is going to do for the business and how that should be legally documented is very important. Should they be an employee? Should they be an advisor that perhaps has a fixed role and a fixed contract term? Should they, and then I guess as a third sort of category, you have workers that fall somewhere in the middle. And really the rights and responsibilities of the company in respect of those individuals will really be dictated by what role they have and that legal classification. And Trevor will come on to the sort of tax implications of that relationship shortly. And then the second point is around key terms. And specifically here, we wanted to flag the importance of restrictive covenants, which I touched upon earlier. And really, these are a method of protecting the company. So key employees will come into contact with your key suppliers, customers, other great key employees, and learn know-how and understand confidential information in the business. So when they leave, you want to make sure that you're adequately protected, so they can't take your confidential information, your business, and are at least subject to restrictions that are enforceable under law. So restricted covenants come in a number of guises, but typically you get the non-compete, where they can't compete in a particular business in a particular jurisdiction for a particular length of time. You also can have non-solicitation of customers and employees. You can include a non-disparagement clauses where they can't go out and say disparaging things, whether that's sort of privately or publicly to the market. And really sort of making sure that you've adequately drafted those, whilst also ensuring they're enforceable. So the key thing around restrictive covenants is that they have to protect a legitimate proprietary interest. They have to be reasonable to protect your business. So really thinking about what you are trying to stop the employee from doing, for how long, and making sure that it's tied to specifics. So often employment contracts will have the term of the restrictive covenant as 6 to 12 months post termination. The government's actually discussing at the moment whether that should be reduced down to 3 months, and that's sort of a consultation process at the moment that's going on. And then again, geography, making sure it doesn't prevent them from doing anything globally, making sure it's specific to what your business does and where you operate. And then the final point I just wanted to touch upon was tax. Was confidentiality, that basically they are restricted from dealing with confidential information whilst they're an employee, but not post. So again, making sure that you've got those restrictions in place is critical. And I'll pass over to Trevor now to touch upon tax.
Thanks, Jennifer. Hi all. So it's really important from a tax perspective to figure out at a very early stage the characterization of the people that you engage. Is this person an employee or is this person a contractor? And the first thing I should say from a tax point of view is just because you call someone a self-employed person doesn't mean that he or she falls into that category. It's based on facts and circumstances, and the HMRC Revenue Customs will look at the facts and circumstances to determine the categorization of that person. Why is that important? Well, if you have someone who is an employee, you then become essentially a non-paid tax collector for the government, because you've got to operate something that you're probably dealing with already, PAYE, pay as you earn. And what that means, in essence, is that when you make a salary payment to your employee, you are required to deduct an amount of income tax and national insurance from that person's salary and pay that over to the government. But also, you are required as an employer to pay employer's national insurance, which is 13.8% of the amount that you pay to that person. So it's really, really important that you figure out the categorization up front, because if you get it wrong, then there are penalties and sometimes interest that may be imposed by the government for failure to operate the PAYE system. If, however, the person is a contractor, completely different. You basically make payments to that person gross without any deductions, and then they will be required to sort of deal with their own personal tax affairs. The only other point I should mention is that contractor may be VAT registered, so they will charge you 20% on top of the fee that you've agreed to pay. If you are a VAT registered person yourself, you should be able to get that back. So it just becomes a cash flow disadvantage. If you're not VAT registered, that becomes a real cost. So just, look at that quite closely when you are engaging a contractor. Let me move on to the next section, share option schemes. Now, this is something that we help growing companies with a lot. And it's basically, how do you arrange things so that your employees or your contractors have some form of what I call equity participation in your company. This is something that we see more and more in terms of startups, sometimes because to sort of fill the income gap, it's sometimes called, but most importantly, it's a great way to ensure that your employees, the people helping you grow the business, they have an alignment of interest with you. They want to help grow the company. They want to increase value because, hey, when the company is ultimately sold, they will benefit as well. Is what I say to clients sometimes. It is a way to make sure people get out of bed on a Monday morning, on a cold December Monday morning. So the way you normally see it done is by way of granting someone an option. And what that basically means is that you have an agreement with your employee or your contractor that under certain circumstances, they are entitled to acquire a certain number of shares in your company at a certain price. Now, it could be based on what we call vesting. They must be at the company for a certain period of time. It could be based on performance. It could be based on anything you like. It's a contractual arrangement between you and the individual concerned. What we quite often see for various reasons that we'll come on to if we have time, is that the option will generally only be exercisable immediately before an exit, so that they get the value on an exit, but you don't have to worry about that person being a shareholder during the life cycle of your company. So that's what an option is. So the other point to make is the UK government promotes this form of behavior. They like when employers give their employees options. And to promote that, there are a few very good tax efficient schemes available to you. I'll just discuss one, and that's called the Enterprise Management Incentive Scheme. It is, I say to clients that I act for, if you qualify, you must have one. It's almost a no-brainer. The reason why is that from the option holders' point of view, they are extremely tax efficient. There's no tax when the option is granted. If you satisfy certain conditions, there's no tax when the option is exercised. The only form of tax you will get, if structured in a particular way, is that on the sale of the shares that the employee receives on the exercise of the option, that will be subject to capital gains tax. And capital gains tax is taxed at a much lower rate than income tax. So it's really, you know, the best case scenario. Because there's such, you know, great things to have, there are, as you would imagine, a number of conditions that must be satisfied, both from the company's perspective and from the recipient's perspective. For example, it generally will only apply to your full-time employees. There are exceptions to that, but as a general rule, that's how it works. And as I said, if you qualify, it's a no-brainer. You should have one if you want to incentivize your employees by way of equity. If you don't qualify, all's not lost. We have what we call an unapproved schemes, and these are schemes that don't have the same tax favored treatment, but you know, they still work pretty well. So there's no tax on the grant of the option, but when the option is exercised, there's income tax, which will be higher, will be at a higher rate than capital gains tax. But the beauty is no tax will generally arise until an exit, and in other words, there's money to pay the tax. There are other schemes, but those are the main two that we see startups and growing companies will generally get involved in. So I'm going to stop there, and I'm going to pass it back to Jennifer.
Thanks, Trevor. And I think just to wrap up share option schemes, the key things on the corporate side to think about, and again, it sort of ties into control of your business. But you know, what is the option pool that you're granting? Typically, you would see it being 10 to 15% of the share cap. So making sure you aren't giving away too many of your shares to employees or contractors. So something quite key to bear in mind. And also, what share class are you granting options over? Because when the employees receive those shares, if they have preferred treatment, you know, preferred rights, then that could impact you as a founder in your role. And also, when should those options be exercisable? Should they be exercisable once the conditions have been satisfied on sort of an ongoing basis, or only on exit, you know, again, to retain your control over the operations for as long as possible. So there are various considerations to think about there, as well as, I think we mentioned on the slides here, thinking about how this option plan might impact your contractual governing documents, so your articles of association. And next, we wanted to move on to NDAs and confidentiality agreements. Given, you know, these documents are sort of fairly, you know, are fairly commonly used, and you know, can be very helpful in various scenarios. So the first thing to think about is the what's the purpose of needing this confidentiality agreement? What are you trying to protect against? So are you entering into a NDA to protect, you know, because of third-party advisors coming in? Or is it confidentiality to protect, you know, against a sort of employer-employee relationship, for example? And what confidential information are you sharing? Is it, you know, is it trade secrets? Is it, you know, know-how and you know, proprietary documents? Or is it sort of less critical business information, for example? Because that can determine the form and substance. When was the information provided? Was it provided historically? Are you trying to capture something that's been provided in the past, or is it sort of on a go-forward basis? And are you providing the information only, or are you receiving it as well? And making sure you've appropriately covered those scenarios. The scope of obligations is also very important. How should that information be protected? Should, for example, the counterparty be able to make copies? What level of confidentiality do they need to adhere to? Which again tends to stem from what confidential information, what the level is that you're trying to protect against. Are any other restrictions appropriate? Should there be, for example, a non-solicit if they're being given key employee data that you feel is sensitive? Should there be other restrictions in that confidentiality agreement? And what should the term of that NDA be? And again, that tends to stem from the purpose of the NDA and what you're trying to protect. So what level of confidential information? And typically you see 1 to 5 years, often sort of the 1 to 2 for a sort of transaction style NDA. And then you see the longer periods, and even 5 years up, if it's sort of, very, high priority confidential information. And then the final point we wanted to touch upon was future funding, and really sort of the key things you need to bear in mind if you're looking to secure that in the short to medium term. So the first thing is considering, deal terms and what you're trying to seek. How much are you trying to raise? From whom? What is the valuation you want for your business? What sort of investment do you want to give away to a third-party investor? Do you want to offer them shares in your business? Do you want to offer them some kind of debt, whether that's a loan or some kind of convertible instrument where it converts into shares at some point in the future, perhaps on the next funding round? And what will the monies you've raised be used for? And really just scoping out those key things you are looking to seek. And then tied to that is the preparation. Once you know what you're trying to seek, then moving to get yourself in a position where you could go to market to raise funding. So preparing pitch decks and business plans at an early stage, so that you've got those to hand for investors. Considering involvement of professional advisors to make sure you've got sort of the accounting, tax, legal aspects in line. Sort of data room due diligence considerations in terms of just making sure you're getting ready, but you're not using all of your time to run the process, which can often be the case for founders. So it's much easier to do it over a longer period of time to sort of have all your key documentation in order, and even having sort of an internal database from the outset where you store things that you then could use for a legal or financial diligence review for that process is very helpful. And considering what operational tidy up measures you may need to implement. It's obviously ideally you've started out from your start out stage, you've kept everything in perfect order, all your documents are in perfect order, but appreciate things can fall through the cracks. So thinking about what connected party transactions do you have in place? That can be something an investor is highly focused on. If you're leasing a property in your name, you've loaned money into the business, making sure that you've got your arms around those sorts of transactions and the documentation you've got in place for that. Employment contracts, that's often one an investor will focus on. Have you got documented arrangements? If not, should you be putting those in place before the investor comes in, or negotiating those as they come in? IP, which Stephen will come to shortly, and also sort of on the regulatory side, sort of things around, if you process a lot of personal data, have you thought about regulatory compliance if that's appropriate at that stage? And then moving on, finally, key documents. Once you've done deal terms preparation, then it's thinking about the documents you need to bring in that funding. Often you start with a term sheet and then you'd move into sort of the longer form documents, as that can sort of save time and energy later down the line. And then obviously one final thing to note, just keep your cap table, you know, your list of sort of shareholders and anyone else who owns any ownership interests in the company. For example, the employee share options, keeping an up-to-date and detailed account of those can be very helpful, given the investor will be focused on that. So I'll now pass over to Stephen to talk through the fourth and final section of the agenda.
Thank you very much. I'm conscious of time, so I'll canter through this at a decent pace. So one of the key things I wanted to get across here was the idea of aligning your IP strategy and having an IP strategy in itself with your business strategy, and that you should be planning for that and constantly reviewing it as you develop and grow the business. And so I think there are different limbs to that. The first element is about making sure that you're capturing the innovation going on within your business. Are you documenting inventions that are being created, recording those, making sure that the individuals who are responsible for developing the IP have assigned or transferred their IP to the business? If they're employees, that will happen automatically as a matter of law in most jurisdictions. If they're not, they're independent contractors and they design a website for you or some source code or other materials, then you'll need to get that IP assigned. So capturing that IP is very important. Then there's the concept of developing a filing and maintenance strategy, thinking about what registered rights, such as trademarks and patents, you want to register and how you'll be able to manage those. Then there's a commercialization piece. There's no point having a trademark or IP portfolio if you don't commercialize it. So thinking of how you might want to exploit those rights, and I'll touch upon that briefly in a moment. And then defending the IP that you have. One of the main reasons for having IP is to create a defensible position. It's so investors get comfort, for example, in knowing that someone else can't come out of the woodwork, a bigger player perhaps, and completely replicate your business model. And IP can give you that defensible position. Can I move on to the next slide, please? So I see IP as being a living and breathing asset class that you constantly review, build on, and seek to exploit. It can give you a competitive advantage. There are different types of IP rights. There are registered rights such as patents and trademarks. Patents protect the functionality of certain products and processes. Trademarks are typically used to protect elements of your brand and iconography. And then there are unregistered rights such as copyright, which is raised automatically. And the key there is making sure that you're documenting and recording things as you go along to assert your copyright. And when you're looking at IP, consider taking a global approach. You can't get a single patent or trademark that can register your IP in the whole world. So you have to start thinking in a more strategic way about what are your likely core jurisdictions. And if we can move on to the next slide, please. And then the key, particularly when you're a startup or scale up business, is to identify, well, what's the most important to you, and what type of IP is the most important to you, and what's going to be important for certain businesses might be less important for you. So if you're in retail, for example, trademarks and registering those trademarks and brand protection are likely to be more important to you. Whereas if you're a pharmaceutical business, things like patents that cover the products and trade secrets, which protect confidential information and know-how may be more important to you. But again, when you're thinking about IP, you need to be thinking strategically. There are, for things like trademarks and patents, grace periods that you can rely on and refer to stagger your application process. For example, if you're looking to file a trademark, you may want to file in the UK first, and then you have up to 6 months to be able to file in other jurisdictions and backdate that original backdate those later filings to your original UK filing date, and that helps you to stagger the cost. The same can be done with patents, where you file an initial patent application and then look to file in other jurisdictions over 2 to 3 years, whilst you look to develop the investment that can help you exploit those rights. And then identify your market. You shouldn't be registering your IP in every single jurisdiction over the world. Look at where your key markets are and where you're likely to enforce those IP rights. And the next slide, please. And then the key with IP is to commercialize that IP. And you can do that in a number of different ways. You may choose to automatically assign or transfer the rights that you created to a third party and immediately realize that value. You may also choose, which is very common, to license the IP rights that you own to third parties who are in a better position to exploit your rights in other territories in return for a royalty. And you can like split IP up and license it in multiple different ways. So you can do it by territory, by sector. You can make the license exclusive, so only one party can exploit it. You can make it non-exclusive. There are many, many different options. You may choose to exploit the rights yourself, or perhaps even charge or mortgage your assets in order to release value into the business. You also need to think about third-party IP too, and what rights you need to license in to make sure that you can both use the IP that you created, or if you're not generating a huge amount of IP, to make sure that you can continue to use the core IP, whether it be source code or other materials in your business. And then if you're stuck about what to do in terms of how to develop your IP strategy, a good tip is to look at what are your competitors doing? What patents have they registered, and for what kind of products? What kind of trademark strategies have they taken? Have they registered word marks, logo marks? Where have they filed their trademarks? And that can give you a good indicator, and you can speak to IP professionals who will be able to do some searches for you. And that may also help you to avoid infringing your competitors' rights as well. So I think the key with IP and formulating strategies, that it should sit alongside what the business's key objectives are, and making sure that you look at IP early and put those building blocks in place to enable you to exploit the rights and grow as you develop as a business. And that's it from my side. I don't know, Jennifer or Amanda, if I'll hand back to you.
Great, thanks very much, Steve.